All right, folks. Good morning. Today, we just have two rights that we need to talk about: freedom of the press and right to bear arms. Got a little different location for you today. That I do it from the lanai here. And here we go. So, first thing is the freedom of the press. We're returning to the First Amendment. So, you know that according to the mnemonic device, First Amendment, five rights. You've got speech, religion, press, assembly, petition. Today, we're talking about freedom of the press. Right. So here's your first court case that you do need to know. It kind of set the precedent for the required case. So Neer versus Minnesota. In this particular case, Jay Neer, had a paper that he owned here in Minnesota. It was called the Saturday Press, and he published some information concerning Minneapolis public officials that linked them to gangster activities. So these Minneapolis public officials responded, their government, and they said, you know what? We're just going to shut down your newspaper. They exercised what we call prior restraint, censorship prior to publication. Now, the prohibition on government exercising prior restraint is something that goes all the way back to England. It was a prohibition that was brought over by the colonists here to North America. So there's a long-standing tradition that government should not exercise prior restraint. They should not be engaged in censorship prior to publication. In this case in Minnesota, they did so, but it went all the way to the Supreme Court. And what the Supreme Court said is yes, censorship to prior to publication, prior restraint is unconstitutional. But they left the door open for certain circumstances, especially national security. And in the cases involving national security, prior restraint might be warranted. Which brings us to our required Supreme Court case, New York Times versus United States, years 1971. It's the Vietnam War era, and the New York Times gets in possession of some documents called the Pentagon Papers that outlines the history of the United States involvement in Vietnam, this very unpopular war. And they publish like the first chapter of the Pentagon Papers. The Nixon administration steps in and they exercise prior restraint. They say, you can't publish that. That's going to damage our national security interests. And they shut it down. The New York Times sues. It goes all the way to the Supreme Court. And in this case, the Supreme Court concluded, and this is very important here, is that there's a heavy presumption against prior restraint. That in cases where the government wants to censor prior to publication, we're going to assume that it's unconstitutional. That's the heavy presumption piece, that prior restraint is unconstitutional. And it's up to the government to prove that it's necessary. And even in cases involving national security, the government would have to prove that there's an immediate event imperiling the safety of American troops. So it has to be something like, hey, the troops are going to land on this shore at this time on this day. And if the enemy were to find out that location and time and place, the troops would be killed. Then prior restraint would be warranted. In the case of the Pentagon Papers, it was unwarranted. And New York Times was able to publish them. All right. So that's kind of your case that you need to know when it comes to the AP test. All right. Other cases involving the freedom of the press. So you have this case that I don't really understand why it's not a need to know case, New York Times versus Sullivan. So we've talked about libel before. Libel is the publication of false information intended to damage the character and reputation of a person. Libel is when it's in print. Slander is when it's spoken, when it's speech. And we know that it's not protected speech. Now, in the case of New York Times v. Sullivan, the New York Times had published an ad to raise money for the legal defense of Martin Luther King Jr. Okay, he had been accused and was on trial for some crimes in the South. And in this particular case, there was some factually incorrect information that was published about the Alabama State Police. So the Public Safety Commissioner, Sullivan, sued the New York Times for this factually incorrect information that was in the ad. And it went all the way to the Supreme Court. And the Supreme Court looked at this factually incorrect information, said, yes, there is some information in here that's false. But if that is the standard for libel, that is going to have a chilling effect on the freedom of the press. The press is going to be unlikely to print information that is critical of public information if the standard is that all you have to do is prove that it's false. So they created a standard for public officials called actual malice. So you see a couple examples down here of the president, suggesting that he might sue for libel. Well, the standard would be is that he has to prove that the New York Times knowingly published false information for the purposes of damaging his character, not for the purposes of informing the public, or in the case of Saturday Night Live, not for the purposes of entertaining the public. Because satire is also protected speech, and sometimes they engage in, publishing factually incorrect information. Okay, so the lesson to be learned is that the more public of a figure you are, the thicker your skin has to be. So I'm a public school teacher. So if one of you were to get online and to create like a false website and publish some factually incorrect information about myself, I would have to prove that you did so knowingly, you knew the information was false, and you did so with the intent to damage my reputation and character, to make it so that I was unable to teach. That, in fact, maybe you did it with the purposes of trying to get me fired. In that case, I could sue for libel. Otherwise, the more public of a figure I am, if I'm the governor of Minnesota, the president of the United States, just the thicker my skin has to be. I just have to take it. All right. So New York Times v. Sullivan, actual malice is the standard for a public official to prove libel. That's your freedom of the press. You got 3 court cases: Near versus Minnesota, okay, established the or reiterated that there was a prohibition against prior restraint. And then New York Times v. Sullivan expanded that to include national security, that it's, prior restraint's unconstitutional and you have to prove otherwise if you're government. And then you got New York Times v. Sullivan, libel and actual malice. All right, let's move on to the Second Amendment and the right to bear arms. This is an interesting one because for years and years and years, the Supreme Court did not want to get into the Second Amendment. They would not take up cases that would require the interpretation of the Second Amendment. So what is the language here? Well, the language is short. It's a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And there was an ongoing historical debate about what the Second Amendment actually meant. Does it mean that there's a public right, kind of a communal right to have arms that would be necessary for the defense of the country? Or is there an individual right for a person for their own personal self-defense? And the national government, for years, the precedent is they weren't going to take up these cases and help with the interpretation. They left it to the states and to state constitutions to determine how extensive that right was for individuals and the people. Well, then we get to the year 2008. So your first court case, you have to know this one just because it sets the precedent. District of Columbia v. Heller, years 2008. The scene is the District of Columbia had some laws that prohibited the licensing, like who could actually own a handgun. And then if you did get a license, in your house, you had to keep the handgun in a non-functional state. You had to keep it disassembled. So for all intents and purposes, I could own a gun in District of Columbia, a handgun, for recreational use. I would have to keep it in a non-functioning state. When I wanted to go to the firing range to practice my marksmanship, I would take it there, assemble it, do so, disassemble it, and go home. Okay? Now, so the question before the court was, were these laws a violation of the Second Amendment? The conclusion is simple. The Supreme Court said yes, the Second Amendment guarantees an individual's right to bear arms. So you had a court that looked at the first clause about a well-regulated militia and really said that's a preface. That's just kind of setting the context for the description of an individual's right to bear arms. Okay, it's not the complete context in which an individual would have a right to bear arms. So it was the first time that the court recognized an individual's right to own a gun. Now, because it's DC, you have to recognize that they're really only saying the national government cannot infringe on your Second Amendment rights, which leads to our second case. Okay, this is the AP required case, McDonald versus the city of Chicago. It's just 2 years later, because as soon as the court came out with their opinion in Heller, all of a sudden there was lawsuits that were happening. And so there were several lawsuits that were filed in Chicago because they had a ban on guns in Chicago. So it was the same question. Well, actually, it's slightly different. Sorry. Does the Second Amendment apply to the states and its subdivision? If it applies to the national government, does it apply to the states? So in McDonald versus the city of Chicago, you see the incorporation of the Second Amendment. They said yes, via the due process clause of the 14th Amendment, okay, that this is a liberty. The Second Amendment presents a liberty that is a protection against state government intrusions as well. So now, not only can the national government not infringe on your individual right to own a gun, but state governments can't as well. Now, what are the reasonable regulations on gun ownership? Those are up for debate, and you'll see differences in different states about that as well. So one final case on gun ownership we've already talked about, and this was another one of your required cases, U.S. v. Lopez. In this case, there was a national law passed by Congress that banned guns in a school zone, the possession of a gun in a school zone. But they didn't do it under the Second Amendment. They argued that they could do it on the Commerce Clause. So completely different part of the Constitution. And in this case, the Supreme Court said no. It was the first time that they had said no to the national government when they argued that they had an implied power based on the Commerce Clause. And the Supreme Court said possession in itself is not commerce. Okay, so just remember U.S. v. Lopez. It's about guns, but it's not a Second Amendment case. It's a Commerce Clause case. Well, that's all we have for today. So you have freedom of the press, right? First Amendment, 5 freedoms, and one of them is press. And the required Supreme Court case is New York Times versus the United States. It's the Pentagon Papers case, okay? That prior restraint, there is a heavy presumption that it's unconstitutional. And then you have your Second Amendment, number 2, boom, bang, bang, okay? Right to bear arms. McDonald versus the city of Chicago incorporated an individual's right to bear arms. Okay, that interpretation that it is an individual right, that happened in D.C. versus Heller. All right, folks, I'll see you. And tomorrow we're moving on to civil rights and equal protection. And that will be super fun.